Yes. Mr. Beals Renshaw is here today after failing to appear before referee Snyder on April 8th, 2024. Bond is currently set at $2,903. This is the first bench warrant. He reports that he is employed by WSI working at Denso. Last payment made on this account was in October of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on May 8th, 2024 at 8:45 a.m. before this court.
Thank you. Mr. Beals Bradshaw, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on May 8, 2024 at 8:45 a.m. Are you able to post a bond, sir?
I actually just started working. That's the problem. Because I've been helping out a veteran.
Okay. So how long have you been at WSI?
I just got hired in there on Thursday. And I worked Friday, Saturday, and then obviously I got arrested yesterday.
So you're not able to post anything as a bond?
Not at the moment, besides my word.
Well, what I'm going to do is, it is your first bench warrant. I'm taking that into consideration, but you haven't paid in a considerable period of time. What I'm going to do is I'm going to set your bond in the amount of $0. That'll allow you to get out so you can go to work. You'll have to contact your caseworker this Wednesday, okay?
Okay. I do have a question though, because every time I tried calling the front of the court, because me and my ex-wife, she wants to help reevaluate the payment because it's like $321 a week.
Okay, what's the question?
And I didn't know exactly how to do that because every time I call, they just give me the runaround.
Well, what you're gonna have to do if you want to do a review, you have to do that in writing by filing a motion with the circuit court clerk's office.
Okay.
And in this case, you'll get paperwork that'll tell you to call in on Wednesday morning, talk to your caseworker, see if you can't get things resolved. If you can, then you wouldn't have to come back in for a hearing, but I think you'll be able to get something resolved with them. So I'm letting you out because we want you to keep your job. Make sure you tell the job that you do have that support obligation so that they can start doing income withholding.
Yes.
Okay. Okay, it'll probably take you about an hour or so before we get the orders before you can get released, sir.
All righty.
Okay, have a good day.
You too.
Mr. Curtis is here today after failing to appear before this court on March 27th, 2024. Bond in each case is currently set at $500, and this is the fourth bench warrant in each case. He reports that he is employed at Magna. Last payment made on these accounts was on May 1st of 2024, and that was through income withholding. This is the second payment through that employer. Front of the court requests that reasonable bonds be set in these matters and they be scheduled for hearing on May 8th, 2024 at 8:45 a.m. before this court.
Thank you. Mr. Curtis, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Court notes that you did make a payment back on June 1, 2024. What the court's going to do is I am going to set your bond in the amount of $0. That will allow you to get right out today so you don't lose your job. You'll have to contact your caseworker on Wednesday morning to talk to them to see about what we'll have to do on the Wednesday hearing, okay?
Yes, sir.
Being that you are paying through income withholding, I anticipate you'd be able to get something worked out, but you still have to call them and make arrangements, okay? If you don't call them, they're gonna put in place a new bench warrant. You'll get picked up again.
Yes, sir. I ended up moving. I just moved into my townhouse, and it just I didn't receive the mail. I'm getting everything switched over. I have my mail going downtown right now, so I'm just moving in on it.
Well, what you do is when you get out of jail, go down to the front of the court's office and then fill out a change of address form.
I've done that. I just done that last week. I just did it last week.
Okay, great. We will then hear back from you or from your worker on Wednesday, okay?
Yes, sir. Appreciate you.
Okay, have a good day, sir.
Thank
Court will
you.
note the appearance of Ms. Capture on behalf of plaintiff. This matter is before the court on the plaintiff's motion to modify exchange location and child support. Ms. Capture.
Thank you, Your Honor. As it stated in our motion, circumstances have changed so that the current order is no longer correct. It's not the midway point, but what I would like to go further into is the background of these, the reason the order is incorrect in the first place. These parties came together, I believe, in 2021 regarding an exchange location. At the time, Mr. Matert was represented by counsel. During the hearing, you ordered, because you were the judge in this matter, had ordered that the Wayland exit would be the exit that they used, but that was a simple throw out exit. The parties needed to come together to make an agreement as to what would be the proper midway point. Communication between Mr. Matert's attorney and Ms. Sokol broke down, wherein he stopped communicating via email and then just simply submitted a 7-day order. He did not submit that to Ms. Sokol via email. Instead, he snail mailed it. As a result, it wasn't received by Ms. Sokol until after the 7-day period had gone. However, despite that, Ms. Sokol knew that, she wanted to continue trying to co-parent effectively with defendant. And since then, she's been driving more than the halfway point to that Wayland exit that's contemplated in the order of 2021. Since then, there's been a few changes. First and foremost, it's never been the midway point, but she still has moved further away. She's tried to communicate with defendant multiple times. I've even tried to reach out to defendant to try to get the parties to agree to a midway point so that they can meet halfway to exchange the child. It's an onerous drive. Ms. Sokol is driving an extra hour to exchange the child, and she just wants some relief. But defendant hasn't been able to work with her on that. And so we're asking that the court order that the midway point be the one I've described in the motion, which is the actual midway point between the two parties. Also, there's just been a change of circumstances with regard to the two parties' jobs. It's been 4 years since the two parties have calculated child support pursuant to the Michigan child support formula. Being that Ms. Sokol now has a different job, Mr. Matert, I believe, is now making more money. Obviously, Ms. Sokol, my client, has primary physical custody and sole legal custody. And so at this time, we believe it is proper to move for a change of circumstances and reevaluate child support. Thank you.
Okay, thank you. Mr. Matert, what's your response?
I'm making the same amount of money as I was making the first time, and I don't see, if she keeps moving, I don't see the fact that I have to do the extra driving if she keeps moving. Okay.
Anything else, Ms. Capture?
Yes, Ms. Sokol hasn't kept moving. She's moved, wants to initiate this change. Any other moves, obviously, she hasn't been going to the court to keep reevaluating the exchange location. This is the first time in 3 years that she's asking for this, which is a reasonable request. Again, she's tried to work with defendant to try to get this done collaboratively, but Mr. Matert has just refused to work with her, which again goes to the fact that they don't co-parent very well. I think the big thing here is that Ms. Sokol is working nights. She works about 30 to 40 hours at night. And so it's quite onerous to drive the extra hour both ways. So it's an hour one way, it's an hour the other way after it's all said and done. And she would just like to cut that time in half. It's share the burden a little bit.
But you acknowledge that she moved and she added the extra half hour onto that time, correct?
No, Your Honor, the location is actually where she moved is not a very far move from where she currently was. It doesn't add time to the location. The issue is that the original location, the midpoint, was thrown out, and she tried to agree with defendant. However, that Wayland exit was thrown out during the hearing when you had ordered that it be a midway point. She couldn't get an agreement with previous counsel. Counsel simply ended up going with the Wayland exit, despite the fact that it was not the midway point. And so she has tried to work with defendant to try to just come up with a.
I thought you put in your motion that she had moved.
She has moved, but it hasn't added the 30 minutes. It's the move, I think, adds maybe 5 minutes of a difference. It's that location itself hasn't added the 30 minutes. The core of the issue is that the 30 minutes extra time was a mix-up at the very original order.
Okay. Well, in this particular matter, Cora would note that she did move. It added a minimal time to that particular order. Obviously, there was some confusion or issues as to the exchange point, but the court doesn't believe that it is sufficient to change that exchange point. I'm going to keep it. The parties have been doing that since 2020. The court will keep it at the Wayland, wherever they're meeting in Wayland. The court does believe there's a basis for again, modification, at least to review the support, the court will send that matter to the referee for an evidentiary hearing in this matter. So, Ms. Capture, if you would prepare an order denying that, but then the other is sending it to the referee, and we will do an order sending it as well.
All right, thank you, Judge.
Okay, thank you. You're free to go. Have a good day. Note the appearance of Ms. Podolsky on behalf of plaintiff. This matter is before the court on the plaintiff's motion for modification of custody, parenting time, and support. Ms. Podolsky.
Thank you. As this court is aware, Your Honor, we were here in the late summer of 2022 with a very similar issue. The minor child expressed concerns about the happenings at mom's house. She actually had a sit-down meeting with her parents and stated, look, I don't want to spend time during the week at mom's house. I want to stay at dad's during the week, and I'll go to mom's on weekend time. The parties exercised that for a while, then had another family meeting wherein it seemed things had gotten better at mom's house and promises were made. And so they went back to their current week on, week off schedule. That was in January of 2023 or early 2023. Unfortunately, since then, circumstances have changed again. These were empty promises that were made, and there continue to be issues at mom's house. And since November, the minor child has resided solely in the care of the plaintiff father. The friend of the court has taken notice of this. That first they issued a child support abatement in November of 2023. Since then, they have actually issued a brand new child support order in February of 2024, wherein the current support order is based on 0 overnights for the defendant mother. Neither party objected to this action by a friend of the court, consenting and acknowledging those 0 overnights with the defendant mother. But the circumstances that have changed in the home of defendant mother are that the minor child does not have a bed in mother's home due to the bed bug infestation. Her room is now being used essentially as a catch-all for garbage and other just random items in the home. There are several animals in the home, and there are feces and urine throughout the home. She is concerned about cleanliness and stepping in it. She is unable to get her schoolwork done when in the home of defendant mother. She has expressed concern and anxiety of this, but she is blown off by, unfortunately, her mother due to these concerns. Further, she has a brother who lives in the home who has some criminality issues. He has threatened the life of another sibling living in the home. This is an unsafe environment, and the minor child does not feel comfortable there, and because of this has been residing solely in the home of the plaintiff. In our motion, we did include text messages between defendant mother and the minor child, and defendant mother and the plaintiff. These were from February of 2024, where she stated, have the minor child come get her things from the home because she's not going to be residing there anymore. Since residing in the plaintiff's home, attendance at school has improved. Her grades have improved. She's involved in color guard. She's involved in theater through the school. She's involved in a summer program through theater. Plaintiff has been the primary caretaker of the minor child. He attends to all of her needs, all of her educational needs, medical needs, any care that she needs. He is full-time employed and is able to financially provide for her and does not need the assistance of the defendant in that regard. So based on the change in circumstances, we're asking the court to modify the current orders, award the sole legal and physical custody of the minor child to plaintiff, parenting time to occur at all times and places as the parties can agree, and that we are asking that the brother who has been named in the motion not be present during parenting time when the minor child does have parenting time with mother. Thank you.
Thank you. Ms. Oldenburg, what's your response?
Please unmute.
Ms. Oldenburg, we're going to send you a number where you can call in on the phone and then connect that way, because apparently your computer isn't working. Ms. Oldenburg, what's your response to the motion?
My motion is I would like to spend time with my daughter, our daughter. I have asked Mr. Spinelli for times to spend with Denise, only to be told no. There are some accusations in these papers that I completely are against. We have 3 cats, not 8. I have 9 guinea pigs, not 12. I am working. I just started a job up at Family Dollar up here on Capitol Avenue Southwest by my home. No, I do not have a vehicle. No, I do not have a license. I had a car accident 2 years ago, lost my license. I'm trying to get it back. Just have to get the money saved up to get my license back. I did fall behind on my bills. However, my grandmother, who lives in Colorado, is helping me. It's just going to take some time. Other than that, Your Honor, 90% of what Mr. Spinelli put in there is false accusation.
Okay. Well,
I
the
did
front of the court, hold on. The
but
front of the court did do a new order back in February of this year, which would provide for you that you did not have any overnight parenting time. Is that correct?
that's correct.
Okay.
I have asked to spend some time with Denise. I was supposed to have Denise on New Year's Day. I asked Mark in a text message, may I please have Denise at this time on New Year's Day? Only to be told no.
Okay. Well, it sounds that in reviewing the motion and hearing the arguments, it does appear that the plaintiff has met the threshold of proper cause or change in circumstances pursuant to Barca for an evidentiary hearing. The court will set the matter for an evidentiary hearing, and we can ferret out all of the issues at that particular time. So we will be in touch with you as to when you're available, and then we will have a hearing. Okay?
Okay, thank you.
You're free to go. Have a good day.
Thank you.
You also, thank you.
Thank you, Judge.
24 at 9:21 a.m.
Court will note the appearance of Mr. Hauser on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to continue the front of the court hearing or a motion to modify custody and parenting time. Go ahead, Mr. Hauser.
Yes, thank you, Your Honor. I suppose it would have been back in February of this year before this case was transferred over to Calhoun County. We had about an hour or so long hearing before the friend of the court in Grand Traverse County. A copy of that transcript was attached to the motion. At the conclusion of that hearing, the friend of the court up in Grand Traverse ordered for an in-camera interview with the minor child, actually with Mark McKediak, the minor child in this case, and also set this for a half-day evidentiary hearing. Unfortunately, we weren't able to have that hearing be held, as that was when the case was transferred here. It's our position based off of what has been presented to the court so far in the Grand Traverse County case. There is sufficient evidence in the best interest of the minor children to, at the very least, until a continuation of that hearing can be held, to grant a week on, week off parenting time. Excuse me, until the next hearing of the court.
Okay. Well, obviously, if we send it to the referee back, you're not going to be in Grand Traverse, because if the case been transferred, I can't send it back to them.
Oh, yes, and I'm sorry, and it would be to have a friend of the court hearing to continue here in Calhoun County, not in Grand Traverse.
Okay. Well, the court does find that based upon the allegations, et cetera, that there's sufficient basis to meet the Barca threshold for evidentiary hearing. The court will not change custody without an evidentiary hearing, and the law doesn't allow me to do so. So I'll send the matter to the referee for a hearing on the issue of the custody, parenting time, and support. And I will, at this point, order that the parties do communicate through app close. So Mr. Hauser will do the referral order to the referee, and if you would do the order providing for the parties to communicate through app close or what other, if they agree upon another provider, that'd be fine as well. And then the referee will be in touch with you.
All right, perfect. We'll get that order prepared and submit under the 7-day rule, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Thank you. 9:26 a.m.
Court will note the appearance of Mr. Gardner on behalf of the defendant. The matter is before the court on the defendant's objection to the referee order. Mr. Gardner.
Good morning, Your Honor. For the record, Gary Gardner, P3317 on behalf of Mr. Smith. Nice to meet you, sir. Your Honor, this is an objection to the recommendation from the referee hearing that was conducted on March 13th of this year. Large part of the, I believe the reason for the referee's recommendation was Ms. Smith's testimony that she'd been providing adequate care and that she'd been going to training and everything else. Well, after the hearing, my client determined, as providing me documentation, that Ms. Smith enrolled the child in a daycare on or about January 18th of this year. But it looks like from the records that he's provided me that the child went on February 16th, February 19th, and February 20th and 22nd. That's relevant because child developed a urinary tract infection, and Ms. Wood indicated, well, she got that from being at the daycare center. Well, she hadn't been enrolled at the daycare center a lot. This also goes to the fact that Ms. Smith said she'd been receiving some educational training to be a nurse's aide, and that the information that Ms. Smith had provided was not accurate. We don't believe that Ms. Smith is continuing or has really gone very far on her healthcare aid training. And this is our right reason for the de novo review. We'd like to have a full hearing on the issue of the initial petition.
Okay, thank you. Ms. Wood, what's your response?
I would just like to say that my daughter's been in daycare since January and did not stop until the end of February or beginning of March when she did get the UTI because of them. And I just got her into a different daycare. And all of Mr. Smith's, he lied to the court last time. And I'm just kind of done with him. He keeps telling our daughter that he's going to take full custody of her. And she doesn't understand any of this.
Okay, anything else?
Not at this current moment.
Okay, anything else, Mr. Gardner?
Not this time, Your Honor.
Okay. Well, obviously there's some issues here. I'm going to refer the matter back to the referee for a continuation of the evidentiary hearing. And that way maybe we can get some of this ferreted out and then see what happens. If it comes back, then maybe we'll have to have a evidentiary hearing, but I'll send it to the referee for a continuation, and then you can, Mr. Gardner, you can present all of the evidence that you have at that time.
Very good.
Okay, thank you.
Over now.
Have a good day.
You too.
Am I still able to make notes on the adjournment today, Your Honor?
I don't understand what you're asking.
As in, make a statement to what Miss Jessie said.
Miss Jessie, I don't.
That's
Miss Wood?
Jesse Wood. He was represented by Attorney Holland.
Okay. Oh, he's represented by Howard?
Yes.
Okay. No,
Gardner, sorry.
Okay.
The last hearing.
No, sir, your attorney spoke for that at that particular time, so we won't take any testimony from you.
2024 at
Okie
9:31 a.m.
Court will note the appearance of Ms. Sachs on behalf of the plaintiff, and we did have Mr. Holack on behalf of defendant, but we had a different screen name. Was that just the screen name, sir?
Good morning, Your Honor. I'm just covering for Mr. Holick. He does represent Jackson, but it's the same law firm, Your Honor.
Okay, what's your name, sir?
Kurt Richardson, appearing on behalf of Wesley Jackson.
Okay, Richards?
Kurt Richardson, P7.
Okay. Okay, thank you. Matters before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Sachs.
Good morning, Your Honor. The parties come before you today asking for rules to have in place during the pendency of this case, mostly due to the fact that the children have had no involvement with Mr. Jackson over the past year and a half. The parties separated and completely cut off communication with one another. And in that time, the children went from a few months old to now a few years old. During the period of time before the parties separated, there were significant safety concerns raised as pled in the motion. The most severe that we see as an ongoing issue right now is Mr. Jackson's unknowing giving of different allergens that are known allergens to the minor child, age 4, to him. They've had issues before the time that the parties separated, as well as a few weeks ago at this point. There was a secondary incident. Luckily, that one was able to be solved without hospitalization. But at this point, due to the fact that Mr. Jackson is a virtual stranger to these children, and the fact that there is an ongoing safety concern that is held, we are asking that there are no other reasonable supervisors that could be done for this parenting time beyond Family and Children's Services, because there are no family members of Mr. Jackson's that are living in the state to our knowledge, as well as Mr. Jackson has made threats against the lives of both Ms. Mendelson and her mother at various times. So there is in fact no alternative that we see other than asking that Family and Children's Services be the party that actually supervises that parenting time. Further, Your Honor, we ask that our family wizard be used for all communications, and that Mr. Jackson be prevented from consuming alcohol or drugs at least 8 hours prior to parenting time.
Okay. Mr. Richardson, what's your response?
Thank you, Your Honor. Mr. Jackson is a father that stands ready, willing, and able, wants to see his children. He's been denied that right. There has been previously a PPO in place, but he disputes the allegations in the motion, and I think the motion itself, the Exhibit A, merely documents his attempts to see his children, which have been denied by the plaintiff. Your Honor, there's a litany of issues here. We don't see any reason at this time that there needs to be any supervised parenting time. He should be allowed to have a reasonable amount of parenting time, at least every other weekend. Your Honor, we think it'd be appropriate here for a referral to friend of the court for an evaluation. But again, a number of the allegations made here, Mr. Jackson disputes. He is employed. He is attaining stable housing. He doesn't use drugs and alcohol as alleged. He's here and wants to be a part of his children's life. And thank you, Your Honor.
Okay, thank you. Well, in this matter, it has been a period of time, a substantial period of time from which he had not seen the children. So to maintain the status quo, the court will order that the plaintiff receive the custody of the children. Support will be pursuant to the child support formula and guidelines that the defendant will provide to Ms. Sachs confirmation of his income within 10 days of today's date. That at this time, because there has not been the contact, the court will order supervised parenting time through Family Children's Services, and that in fact defendant will be responsible for the cost of that at this particular time, and we will do that so that we can start at least having some contact. Or court will order that the defendant not consume alcohol or drugs for at least 8 hours prior to the parenting time, and that the parties would communicate through our family wizard, and that they would confine that to communication to issues concerning the children. Ms. Sachs, I'll have you prepare that order and submit under 7 days.
Understood. Thank you, Your Honor.
Okay, thank you both. You're free to go. Have a good day.
24 at 9:38 a.m.
Court will note, I'm sorry, I didn't get your name again, sir. What's your name?
Attorney Michael Kelly, Your Honor.
Kelly, okay.
I'm
here, note the appearance of Mr. Kelly on behalf of the plaintiff, Ms. Henderson on behalf of defendant. This matter is before the court on the plaintiff's objection to the proposed order. Okay, Mr. Kelly, tell me what's wrong with the proposed UCSO.
Well, Your Honor, in reviewing the order from which it was based on, it says essentially very little in regards to child support. And indeed, the actual order indicates as to child support that the child support review is granted or the objection to the child support review is granted. And in regards to the specific language for child support in the order, Your Honor, it just simply says the objection to child support review filed September 19th is granted, that a modified uniform child support order shall be prepared and entered. A proposed modified order dated August 29th, 2023 shall be entered. There's no other language there. We get the uniform support order and my client's imputed at double what her actual wage is. And more so, backing up slightly, the objection filed to the child support review was not as to income. It was as to the idea that I'm getting parenting time. That's literally all it said. So that being the case, it's my understanding in reviewing what documents I have, the front of the court verified income for both parties 3 different ways, directly from the parties through a wage, through verification, through employer disclosure, and check stubs that each party provided. So the income information is accurate, so that should have been used. However, Your Honor, in relation to what happened or didn't happen at that hearing, I'm at a disadvantage because we do not have the transcripts to see exactly how this came about. But in talking with my client, it doesn't sound like any of the imputation factors were even considered. There's no reference in the order that indicates they were even considered. It's unclear how they came to a $15.50 per hour at a 40-hour week imputation for my client. Minimum wage in Indiana, Your Honor, is $7.25 an hour. When you review the child support figures that front of the court had used, oddly enough, the wage that she had is minimum wage at 40 hours a week, 52 weeks a year. So I think what makes the most sense, Your Honor, is we do have objections we have filed to this particular order that's addressing the parenting time issue, that we'd likely get a evidentiary hearing on. It may make the most sense to address all this at that point in time. We would simply request this morning that the court not enter the proposed orders as presented, based not only on our objections this morning, but also with the understanding we have a further hearing in this matter coming up. Thank you, Your Honor.
Thank you. Ms. Henderson, what's your?
Thank you. Thank you, Your Honor. There was actually a specific finding made by referee Snyder at the hearing due to Ms. Coolidge's voluntary underemployment that she be imputed at $15.50 per hour, 40 hours a week. That was a specific finding made at the last hearing. I was ordered to prepare the 3-tier order, which I have done based on the parenting time that was stated on the record. And that is what I have submitted to the court under 7-day. Your Honor, Ms. Coolidge did not have any representation, and essentially all of the evidence that she tried to submit during the 4 hearings that we had was not allowed by the court due to it not being submitted correctly. Ms. Coolidge did not like the result of the hearing that she got, and now she's trying to essentially have a rehearing without a proper cause due to the fact that she was not prepared to the last 4 hearings. So, Your Honor, I would ask that the proposed orders be entered as a 3-tier order that I submitted under 7-day. We would be filing a further response to the objection as to the parenting time. Again, Ms. Coolidge did not like the result that she got, and she wants to further prohibit my client from seeing the child. But as to the child support, there was a specific finding. She is voluntarily underemployed. All of those factors have been gone through during the hearings. And I don't see any evidence of any transcripts being ordered except for Mr. Todd ordering the transcript of the findings hearing on 4/22/24. However, no other transcripts have been ordered. Again, this is an attempt to delay entry of orders. Ms. Coolidge already violated the order that has entered and has a contempt hearing coming up next week. So, Your Honor, we're asking that the court does not allow this to continue and enter the proposed support orders as they have been submitted. Thank you.
Okay, thank you. Well, in this matter, the court does note the plaintiff was not represented, and the court always likes to have an party have an opportunity at that. What I'm going to do is I'm going to refer the matter back to the referee for a continuation of that hearing and allow the plaintiff to present, now that she has representation, any evidence or argument that she wishes to make. I'm not ordering a full-blown hearing, but just simply a rehearing to address those particular issues and to allow her an opportunity to, again, present that through counsel. So that will be the order. We'll prepare the referral order back to the referee, and you'll be contacted at hearing. Free to go. Have a good day.
Your Honor, based upon you preparing the referral order, is there a need for our office to prepare an order essentially saying what you're saying in the referral order?
No.
Okay. Thank you, Your Honor.
Okay, thank you.
Thank you.
24 at 10:33 a.m.
Court will note that this matter is before the court on the plaintiff's objection to the referee recommended order in this matter. Mr. McMillan, I note that you state that in the motion or your objection that defendant did not submit medical documentation of not being able to work. Anything else that you have in regard to this matter?
Yeah, I went and I retained Katrina Capture for this at Christ and Enderley. And under her advisement and all that, obviously, for the safety of the child, for the necessity of the child, yes, there was a paper that was presented, but we don't know anything other than who did it. You know, I mean, I don't know who it is. I know that nothing was looked into for any expenses for her. I mean, it was literally submitted, and we just need to review this.
Okay, well, at this particular point, the court did review it, see that it was attached as Exhibit A, and it says in that order, it says that patient is temporarily disabled. Patient may return to work and it says to be determined. It's signed by Tamara J. Kelly on 4/4 2024. And as a result, I think obviously the referee relied upon that. And I don't see that the referee made any legal or factual error. If in fact you do some research and you determine that that's an error or there's a problem with that, you have a right to file your motion at that point to claim that there was some fraud on the court, et cetera. But based upon what we have currently, the court does not have a basis to set aside the referee's order in this matter. So the court will, in fact, deny the objection. And should you have other information or documentation, you have a right to file whatever appropriate motions you can. Okay?
Thank you. Yeah, thank you. I appreciate that.
Thank you. Have a good day.
You as well. God bless.
7 a.m.
This matter is before the court on the plaintiff's motion to determine child born out of wedlock as to also join a defendant in this particular matter, that being Brian Matthew Boise. Ms. Johnson, in this matter, I do note that you have, again, made various allegations that would be appropriate to exclude the defendant in this matter. However, I will tell you what happens. We're going to have a hearing to at least take some testimony. And the court doesn't do that on Mondays because we have, as you can see, we have a lot of motions scheduled. That would be set for a Wednesday at 1:30. So what I'll ask you to do is contact my office and find a time when you're available and when Mr. Johnson's available, and then we can set it for a Wednesday and we can take some testimony.
Okay.
It won't take long. It usually takes about 10 to 15 minutes, so it won't take long, but we do have to get some testimony on record.
Okay.
Okay, and the court will grant your motion to join Mr. Is it Boise?
Basie, sir.
Basie, to join Mr. Basie as a defendant in this matter. We'll have Mr. Basie at the Wednesday hearing as well, and then we can take testimony. Okay?
Okay.
Okay, thank you very much. You have a good day.
You too.
2024 at 10:39 a.m.
Court will note that this matter is before the court on the defendant's motion to set aside referee recommended order filed by defendant. Ms. DeWolf, what's you have to establish that the referee made a factual or legal error to be able to set that aside. What is the factual or legal error?
The fact that my kids have come out and stated that they were sexually assaulted by their father. And I do have a letter from CPS stating that he was deemed.
Okay, you say you have a letter. Did you present that to the referee?
I tried to, however, he would not take it.
Why is that?
Because he said that he was there to apparently bring the kids back to Michigan and didn't want to hear any evidence.
Well, that would be unusual for the referee to do or say that. I don't have anything else presently before the court to be able to determine that. What I will do, Ms. DeWolf, I'll send this back to the referee for further hearing, at which time you can present whatever evidence you have in this particular matter. But you're going to have to do that. If my recommendation to you would be get assistance of attorney so that you can present everything correctly, because it sounds pretty serious. I'm not going to pass upon it at this point because I don't know. I just say it sounds serious. The court will send the matter back to the referee for further hearing, and we'll see at that point what the evidence presents.
Okay, and how do I submit that to you guys?
You don't submit that to me. You submit it to the referee at that particular hearing. So that's why I say you might want to get assistance of an attorney to help you in this matter, because court can't give you any legal advice. You're going to have to just, when you choose to represent yourself, you're governed by the same laws and rules that the attorneys are. So you're going to have to do that. So
Well, the only reason why I was asking is because I'm currently in Tennessee, so I don't know if a Tennessee attorney would be able to assist me or not.
Again, probably not, because they don't practice in Michigan, but you can always contact an attorney in Michigan too.
Okay.
Okay?
All
Okay,
right.
the referee will be in contact with you to set up a further hearing.
All right, thank you.
Okay, thank you.
2024 at 10:43 a.m.
Court will note this matter is before the court on the plaintiff's motion to determine child born out of wedlock. In this case, the plaintiff is alleging that, again, that the alleged father, Christopher Jennings Hill, is the biological father in this matter and that the defendant is not. In these matters, Ms. Schulten, we have to have an evidentiary hearing where we take some testimony. And we don't do that on Monday mornings, but it only takes about 10 to 15 minutes. But we have a lot of cases set on Monday, so we can't take testimony. You'll have to contact my office and set that up for a Wednesday at 1:30. And then we would take some testimony at that time. We'll have everybody sworn in and just hear what everybody says as it relates to testimony. Okay?
Yes, sir.
So plaintiff, you'll be responsible for contacting us and setting that up at a time when you're available, and hopefully that Mr. Yulton as well, and maybe Mr. Hill if you're intending to have him testify. You understand that, plaintiff?
Yes, sir.
Okay. Okay, thank you. I'll let you go. You have a good day, and we'll expect to get a call and set that up.
Wait, you dropped down. Can you hear us now, Kevin?
Yes, I can.
Okay, one moment, please, and I'll call us into session. Yeah, and this is for two cases: Lindsay McKediak versus John McKediak in 2024. John McKediak versus Lindsay McKediak, attorney secretary for the Public Defender's Office.
Okay. Court will note Mr. Secretary's appearance in this matter on the 24113 PP. That is the plaintiff's motion or petitioner's motion to show cause for violation of the personal protective order. Mr. McKediak, in this matter, I have to inform you, you have a right to be advised of the alleged violations. The alleged violations show that, or at least state that the respondent, you did call the plaintiff on February 11, 2024, on February 9, 2024, and on March 18, 2024. In this particular matter, all contrary to the personal protective order signed and issued by Judge Yost Johnson on January 16, 2024, which was effective through March 16, 2025. You have a right to contest the charges. You have a right to an attorney. If you cannot afford an attorney, the court believes it may impose jail time. The court will appoint an attorney to represent you. You have the right to remain silent and not have that silence used against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to confront witnesses. You have the right to call witnesses. You have the right to ask that the court would compel witnesses to appear in the event that they will not. As it relates to the show cause for violation, how do you plead, sir?
Not guilty.
Okay. And in this matter, is it your intent to acquire an attorney?
I mean, I assumed after you ruled on my PPO and dismissed all these because you believed she wasn't telling the truth.
I did not, sir, I did not dismiss the PPO against you.
No, you dismissed her allegations of this one. I didn't even know anything about this, Your Honor. I haven't been contacted by anything. I thought we were here for court on the children today.
No, we're not here on the children. We're here on the motion to show cause for violation and the motion to terminate the personal protective order, both filed by Miss McKediak.
To terminate my PPO?
Yes.
Yeah. I mean, I'll need a court-appointed attorney to represent me because absolutely not. And fight these allegations because I'd have to pull my records from my phone because I'm pretty sure these are the same days that we discussed when we had my PPO hearing against her, where she had been calling me and my girlfriend at the time had been talking to her.
Okay. Sounds like Mr. Sackrider that he does wish to have representation, and so he's going to have to file a petition with the court to see if he qualifies for court-appointed attorney. What's your thoughts, Mr. Sackrider?
Yes, I do believe if he does not have the means, the court will appoint him an attorney.
Okay. Well, what the court will do is the court is obviously there's no need to have it heard today, and the court would rather have it be right rather than fast. So the court will grant your request, Mr. McKediak, to adjourn the matter so you can have counsel. You're going to have to come to court. You're going to have to file a petition for court-appointed counsel setting forth your financial situation to determine whether you qualify for court-appointed attorney.
Yeah, I definitely do. Where do I go down at the courthouse for it?
To the circuit court clerk's office.
All right, thank you.
Okay, and then what happens is after that gets done, then the matter will have to be reset for a hearing once we get an attorney appointed. And, you know, if you qualify, if you don't qualify, then you're going to have to retain a counsel and pursue it that way.
Yep.
Okay?
Yes,
okay.
sir.
Thank you. We'll adjourn for today and we'll be in touch as soon as we get that. Please get that court will order that you do that within 5 days of today's date so that it gets expedited. We don't want this matter languishing, okay?
Yes.
Okay. Thank you, sir.
All right, thank you.
Have a good day.
You too.
Krista Trout Edwards versus Ivan Edwards, Attorney Michael Toth for the plaintiff.
Good afternoon to both of you. Mr. Edwards, this is a scheduling conference, and the scheduling conference is whereby the court puts in place various dates as well as procedures so that the case would proceed in an orderly fashion. And I know that you're not an attorney, but I'm going to go to Mr. Toth first as he represents the plaintiff, and then we'll get your input after that. So, Mr. Toth, what issues do you believe to be in dispute in this case?
Your Honor, I think the appropriate way to proceed would be to identify on the scheduling order that really all of the issues regarding the child, I think we have legal custody issues, physical custody issues, parenting time issues. I will concede we have a temporary order that's in place, but there's been really no discussions about any permanent agreements as of yet.
Okay. Do you have any property disputes, any spousal support disputes?
From our perspective, there would not be a spousal support issue. We have yet to really have any substantive discussions, or we've had no discussions regarding any property division. So I would believe that they should all be preserved.
Okay. With that, Mr. Edwards, it doesn't leave much for you. Is there anything that you believe is in dispute in addition to that stated by Mr. Toth?
No, I think Mr. Toth is quite right. We are looking at long-term legal custody and division of property.
Okay. Mr. Toth, are you looking at discovery in this matter?
Yes, Your Honor, I would request there be 60 days of discovery established.
Well, I won't give you 60. I'll give you till July 1. You'll have almost 60 days.
Very good.
Mr. Edwards, discovery is the process whereby you can acquire information from the other side through any of the discovery methods, through interrogatories, which are questions that need to be signed under oath, requests for production of documents, depositions, or any other myriad of procedures under the court rules. So, but I tell you have to do that by July 1. So, because the court's not going to extend that, because we will be setting mediation for the month of July. That is where an attorney mediator will attempt to meet with you and try to help resolve whatever the issues are in dispute. With that, Mr. Toth, do you have any recommendation for mediators?
Your Honor, in light of the fact that John Brundage mediates a vast majority of the Calhoun County divorce actions, I would request that he be the primary mediator with then Kelly Podolsky as the secondary mediator.
Okay. With that, Mr. Edwards, do you have any problem with Mr. Brundage serving as the mediator or Ms. Podolsky as the alternate?
I've never met either, so no, I have no objections at the moment.
Okay. Well, you can look into it. If you do, you can always bring that back up. But just so you know, as Mr. Toth said, Mr. Brundage does about 85% of all the mediations in the county. And so you have somebody very qualified and that to handle the mediation.
Okay, well, I'm happy with that. That's fine.
Court will set August 5th as the settlement conference date. That is a time when we get together. It's at 1:30 p.m. to attempt to, again, see if issues have been resolved. Not at that time, we would then set a trial date if, in fact, there's still a dispute.
Mm-hmm.
Sir, I will tell you as you're going, you'll get a case scheduling order, and it has all these dates and stuff that I'm telling you about. And I'm just letting you know if there are dates and there are things that have to be done, things that have to be filed, etc. For property division chart, witness list, exhibit list. If you do not comply with those dates, you will be barred from bringing those matters before the court. So just make sure that you pay attention to the dates and that you comply with those dates so that you don't get caught.
Yes, sir.
Okay?
Yes.
Anything else, Mr. Toth?
No, Your Honor.
Mr. Edwards, anything else or any questions you have?
No, I'm good. Thank you very much.
Okay, thank you. You'll get this this week, or at least within a week at the latest. And then you should be contacted by Mr. Brundage in a couple weeks as to when the mediation will be in July. And then just prepare to, again, to appear at the mediation and see if you can't get matters resolved. So
perfect.
You're free to go. Have a good day.
Thank you.
All right.
Thank you, Your Honor.
PM, Attorney Carr for the plaintiff, and Attorney Saladicki and Finnegan for the defendants.
Okay. Court will note that this matter is before the court for a status conference. The court previously had a status conference set on 4/8/2024, and Mr. Saladicki, you didn't appear at that time. So we reset this so that you could appear. I guess I'll ask, why didn't you appear at the last status conference?
Yeah, so thank you, Your Honor. Two things. One, thank you to the clerk. That's the first time my last name has been pronounced correctly in the history of court appearances. So I just want to mark that moment. It was May 6th, 2024 when it happened for the first time. Your Honor, we did not receive notice, both Ms. Finnegan and I, and I don't know if it's because we hadn't appeared in the case, or if it was email from Mr. Carr saying, hey, you missed the scheduling conference. So our apologies for not being there, and I appreciate the court's indulgence in resetting the date.
That's fine. Mr. Carr, where are we at in the case?
We have opportunities to go through discovery, I assume. I'm hoping that today you're going to perhaps urge us to go through facilitated mediation at some point, but I'm hoping you'll give us some reasonable schedule to disclose witnesses, complete discovery, and then go through hopefully facilitated mediation and hopefully never have to talk with you again, Judge.
Okay, well, I hope so too. Well, you should have all the dates, Mr. Carr, in the case scheduling order that goes out with your summons and all of that.
So if we're going to live with those, okay, I wasn't sure whether because of this status conference, whether things might change.
No, we live with those unless one of the parties files a motion to change those. I don't have a problem if the attorneys get together and basically move those a little bit, but unfortunately, a lot of times they'll come in, they want to move them out 120 days and all that. I have no problem with maybe moving them 30 to 60 days max, but I'm not going to move them out that far. So you can talk amongst yourselves about that. The one thing I would like is for, let's say, in the next 14 days for the attorneys to come to an agreement as to who the mediator will be and come up with a date as to when you mediate the case, and then contact my office and let us know when that is.
We will do our best, Your Honor.
Okay. Well, that kind of tells me if you can't even find a mediator, then I know where we're headed with the case.
And we haven't tried yet, Judge. So
okay. Okay.
I'm Your Honor. I think we'll be able to find a mediator, and I echo Nelson's sentiment that it's the hope, I think, of all the parties that we can resolve this.
Okay. Well, anything else, Mr. Carr?
No, Your Honor, and thank you.
Okay, Mr. Slattery, anything else?
No, thank you, Your Honor.
Okay, and it's Ms. Ferguson?
Finnegan.
Finnegan, okay. I didn't have it written down, I'm sorry.
No, that's just fine. I don't have anything else, Your Honor,
Okay.
either.
Okay, thank you. Again, comply with the dates in that order, or send me a stipulated order to move or modify the ones that you need, and we'll see if that's reasonable at the time we get it. And I don't have a problem with moving it, but I said it's for a limited period of time.
Judge, can you stick us, the three of us, into a breakout room, or do we have to hang up on you and call each
No,
other?
we can put you in a breakout room if you want. We'll just.
Steve, Susan, do you have a chance to chat right now?
Sounds great.
Thank you, Judge.
If you give me just a moment, I can set that up here for you.
You'll get a prompt on the screen to join the breakout room. So if you hit on that, then it'll set you in the room.
So
Thank
go ahead and you should see that to join room 1. Just be aware that we only have one more hearing after you. And when that's done, we'll close down the Zoom. I think that probably gives you 60 seconds. Just so you're aware.
Okay.
After our next hearing, not meeting 60 seconds from now.
Right.
Okay.
Right.
Thank you. To be able to go there now.
Okay, thank you.
Okay, thank you. Bye-bye.
Thank you.
1:38 p.m. So no resetting the attorney Henderson for the plaintiff, the defendant and counsel are not here.
Okay. Ms. Tongmung, we're going to take some testimony from you. So we'll have you raise your right hand first. We'll swear you in and then we'll proceed.
Okay.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Go ahead, Ms. Henderson.
Thank you. Ms. Thongmong, can you please state your full name and spell your last name for the record?
Heather Lian Thongmong.
Did you request for our office to prepare documents regarding filing for a divorce in late October of 2023?
Yes.
And did you in fact sign and file a complaint for divorce through our office on or about November 2nd of 2023?
Yes.
At the time of filing, have you resided in Calhoun County for 10 days and state of Michigan for 180 days?
Yes.
Have you had a chance to review the complaint prior to signing it?
Yes.
Were all allegations therein true and accurate at the time of filing to your knowledge?
Yes.
Do they still remain true today?
Yes.
In your complaint, you allege that there has been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage could be preserved. Could you please briefly state to the court what happened to your marriage?
We grew apart and it just became very unhealthy environment.
And you have one minor child remaining in your marriage, is that correct?
Yes.
Are you currently pregnant?
No.
Is it true that you and your husband reached a fair settlement regarding all child-related issues as well as property and debt?
Yes.
And that was reached at mediation last week, is that correct?
Yes.
If the judge were not to grant the divorce once the documents are prepared and signed by both parties, is there any reasonable likelihood that you and Mr. Thongmong can go back to living as husband and wife?
No.
May it please the court, Your Honor?
Court is satisfied that the testimony does establish the statutory basis. There has been a showing has been a breakdown of the marital relationship. The court will preserve the proofs pending receipt of the appropriate judgment and orders. Ma'am, you're not divorced until I sign those. It still may take a couple weeks to get those prepared in front of the court approval. And when we do receive those, we will get those entered at that time. So best of luck to you. I hope everything works out for you and you're free to go. Have a good afternoon.
Thank
you, Your Honor.
Right, thank you. We'll close the record here.